Oh, please be seated. Oh, yes, please. Okay, you can come forward and take a seat. Okay, Deputy. Okay, please be seated. Mr. Frank, you may cross.
Thank you, Your Honor. Good morning yet, Mr. Ijames.
Good morning, sir.
Thank you for being here. Talk to you a little bit about your CV.
Yes, sir.
Probably doesn't come as a surprise to you, right? You have been an expert witness before.
Yes, sir.
And if well, it really seems like you've really dedicated your life to law enforcement.
That's my only job I've ever had. Yes, sir.
And really immersed yourself in it, right?
I'd say it's been more than just a career. Yes, sir.
What has it been? More than a career, it's been a calling for you.
It has been.
Something you are completely dedicated to.
I am.
More than a 40-hour-a-week job?
For certain.
In fact, we know from, for instance, in your CV, your resume, there's a section where you talk about, I think the title is Operational Experience. You recall that section?
Yes, sir.
And you're talking there, I think that's about while you were working for the Springfield Police Department?
It may include some other times, but mostly SPD. Yes, sir.
Okay. And there was, you talking there a lot about the work you did during that time period and all of the different things you were able to do as a police officer while working in that capacity, correct?
Correct. Yes, sir.
But even during that time, you were not just working for the Springfield Police Department, you were going out and doing other speeches, conferences, working in law enforcement for other agencies, consulting, correct?
For the U.S. government, yes, sir. For other entities, correct.
Yeah. In fact, during 2001 to 2007, which is the time when you were a major and a commander at the Springfield Police Department, right?
Yes, sir, I was.
During that time, with all those responsibilities, you also traveled really kind of all over the world to do other events for law enforcement agencies.
Yeah, yes, the city of Springfield, not unique to the city, but they decided in the early 90s to partner with the Department of State. We sent 27 officers to Haiti in 94 to assist in creating their national police force. So our department and city were committed to allowing us to participate in things that seemed to be in the interest of the government. So yes, sir, I had that support. If you hadn't had it, you couldn't have done it.
Well, thanks for offering that extra bit. I just simply asked you if you'd done a lot of that, correct? I didn't ask you about the other officers, right?
That's true, you didn't.
Okay, so what you did during that time period, for instance, 2001 to 2007, in 2001 you went to Canada to speak at a Chiefs of Police conference.
Probably more than one, but there may be one reference there if it was significant, yes, sir.
Okay. In March of 2002 you went to Asia to speak for the Department of Justice.
You said Asia?
Yep.
Okay, Indonesia? Is that what it says? I just don't recall the Asia. I mean, I don't think I would have been that general on my CV. It probably was Indonesia or East Timor.
East Timor.
East Timor. That sounds more like what I would have written. Yes, sir.
And that is followed by the word Asia.
Okay.
No geography expert. I can't tell you where East
Yeah,
Timor is.
continent versus country, but yeah, thank you.
Okay. Okay. In 2002, you also went to Canada for the Chiefs of Police.
I'm sure I did, sir.
In 2002, you also went to England for a weapons conference.
Yes,
Yeah.
sir.
In November and December of 2002, you went to Africa for the Department of Justice.
Correct.
In March and April of 2003, you were in Africa for the Department of Justice.
I agree.
In October of 2003, Scotland for a weapons conference.
Yes, sir.
November of 2003 in Jamaica for a conference from the Police Executive Research Forum,
Correct.
law enforcement agency, correct?
It is like the IACP, but for bigger agencies. Yes, sir.
England in 2004, February of 2004.
Correct.
In 2004, in June and August, you were in Greece for the Olympics.
I was.
And in March of 2005, in Yemen.
Correct.
June of 2005, back in Canada.
Agree.
July of 2005, back in Yemen.
Yes, sir.
May and June of 2006, in Uganda.
Correct.
June of 2006, Tanzania. October of 2006, England. October of 2006, Ireland.
Sounds correct.
Those are all for law enforcement purposes.
Exclusively, yes, sir.
And that was just what you did in those years while you were a commander at Springfield.
Correct.
Of all the entries that you told us about in your CV, you have, whether they were appointments or speeches, would you agree that the great majority of them are law enforcement groups,
I think they're exclusively law enforcement groups, sir.
such as the National Tactical Officers Association,
Yes, sir.
International Chiefs of Police,
Yes, sir.
Department of Justice,
Yes, sir.
the Police Executive Research Forum,
Correct.
the Association of Chiefs of Police, right?
Yes, sir.
The Armed Police Officers National Training Conference,
Yes, sir.
the Law Enforcement Television Network.
Yes, sir.
And that's just exactly what it sounds like, is a
It's a training process that gives televised training versus in-person for law enforcement. Yes, sir.
International Association of Law Enforcement Firearms Instructors,
Yes, sir.
the American Association of Law Enforcement Trainers,
Correct.
the Illinois Tactical Officers Association.
That would have been their annual conference. Yes, sir. I would have taught at that.
I'm sorry, I didn't hear you.
At their annual yearly conference. Yes, sir.
Institute for Law Enforcement Administration.
Yes, sir.
Let me just run through some of these, and I'll ask you a question then. The Indiana State Tactical Officers Association, the Ohio State Tactical Officers Association, the Massachusetts State Police, the FBI, Wisconsin State SWAT Association, the Oregon State Sheriff's Conference, the Utah State Sheriff's Conference, the Colorado State SWAT Association, and the LAPD.
Yes, sir.
All groups that you have done things for frequently.
Yes, sir.
And in fact, there's only a couple of things on your CV that are questionable whether law enforcement. You've done some things for the Convoy of Hope.
Sure. I think that might be under a different heading. But yes, sir. Worked for Convoy of Hope doing overseas relief stuff in Haiti and Nicaragua, places like that.
And even with that, you're still providing security and law enforcement function, correct?
It just depends. With Project Hope, no. That's exclusively leading teams at orphanages and things like that. With Convoy, I've done security assessments for them. But the majority of the work overseas in that context is a group called Project Hope, and that's not been security.
Okay. You did some things for the Penn State University Applied Research Lab a couple of times, right?
That's law enforcement, though. I mean, the Penn State Research Lab is less lethal weapons technology.
What you describe as your professional accomplishments are all from law enforcement groups.
Beyond question.
As Mr. Ng asked, the Hall of Fame for American police officers.
Yes, sir.
I'm sure that was quite fulfilling to be elected to the Hall of Fame, right?
Not in the context for what I got it, but understandable.
Okay. What could you mean by that?
It involved using deadly force against a person, and I didn't ask for that award.
Then, the Board of Directors of the National Technical Officers Association.
Yes, sir.
Police Chief Magazine.
Is that reference to being on their policy, or I'm not sure when you say Police Chief Magazine. I've written for them, but I've also done editorial review for them, so I'm not sure what your statement there references, sir.
It's in your professional accomplishments section. So.
Okay.
Those are all law enforcement organizations.
Yes, sir.
Any writing that you have done has been for law enforcement trade magazines,
Exclusively, yes, sir.
including the International Association of Chiefs of Police. It's tough to say. The magazine for that group,
Yes, sir.
and the National Technical Officers Association's publications.
Correct.
So this is something you've really committed yourself to, 110% probably, law enforcement.
I would agree with that.
Career police officer.
It's all I've ever done.
You have also been retained before to offer expert opinions on law enforcement conduct.
Correct.
And just clarify one point, if I could. You indicated on your direct testimony that you have 4 current cases, and this is the only one where you're testifying on behalf of an officer. Is that right?
I've got 4 current criminal cases under review. I probably have 20 civil cases, but only 4 that are criminal.
And this is the only one where you've been retained by the officer.
Correct. In the other 3, it's either an attorney general or a prosecutor would be. I don't know how to characterize it other than to say my testimony would not be supportive of the officer's use of force. That would be the best way to say it.
All right. So I really want to clarify that, because it's true you have been retained in this jurisdiction by another police officer on their behalf, correct?
From my perspective, this particular case from day one was to take a look at the issues, initially focusing on the taser, and just give my...
When you say this case, what are you talking about?
The case we're sitting in right now.
Okay. Well, I didn't ask you about that. You have been retained on behalf of an officer in another case in this jurisdiction, correct?
You mean, do I have another one right now?
Yes. You told the jurors you have 4 open criminal cases, right? You said this case...
I think I'm following you. I've actually got 5. I apologize if I think where you're leading to. I am involved in another case that I just realized that would be more supportive of the officer. So I actually have 5 right now. I've not done an expert report. I've not testified. I may be on the wrong case, but I do have another one I just thought of that I've not done anything on as far as a formal report or anything. So it would be 5.
And I'm not interested in having you talk about the name of that case or anything about that case, but I just want to make sure that it's being represented correctly to the jurors. Okay?
Right. I would have a second case in this jurisdiction that would be, as you're characterizing it, in support of an officer. That's true. I would guess I was trying to focus on those I'd either done reports on or done something formal on, but I currently am involved in a 5th case, so it would be a 2 to 3, not a 1 to 3.
You did a report in that case?
In this current case?
In the other case here?
Yes, sir, I have.
And a lengthy report?
Well, a report, yes, sir. I mean, longer than this one, yes, sir.
testified in court on a number of occasions as an expert witness.
Yes, sir.
These facts of being retained and having testified really not described in your CV, are they?
I couldn't hear the last part of what you said, sir.
They're not described in your CV, your resume, are they?
In my report?
In your resume, your CV, your curriculum vitae that Mr. Eng asked you about.
I don't understand the question, sir. I'm not hearing something, apparently.
I've been asking you questions about your CV, which is for the Latin term curriculum vitae.
Yes, sir.
I assume it's Latin. It's a fancy word for resume.
Yes, sir.
In that resume, you've listed a lot of your experience and your accomplishments and your awards and your trainings, right?
Yes, sir.
But you don't list in there how many times you've been retained as an expert.
I don't think in my CV, no, sir, at all.
And so you do not recall who sought you out or whether you approached the defense in this case or they approached you.
No, I don't think I approached anybody that I can recall ever that I can recall. I had a prior case with Mr. Eng, and I'm thinking the two overlapped. I just don't have a perfect recall of how we got together.
Okay. And you are doing this for free because somebody's liberty is at stake.
As I do in every criminal case, yes, sir.
And that's pretty important.
It is to me.
You indicated in your direct testimony you like to get paid, but you're doing this for free, correct?
I think like most people, you like to get paid for your labor, but some things are more important than money, so that's the decision I made, right or wrong, a long time ago.
You have indicated you have 43 years of experience in law enforcement, correct?
Continuous commission, yes, sir.
You have been doing at least 25 years of evaluating police officers' use of force.
I think that would be fair. It didn't really begin until I was a supervisor, so late 80s, yes, sir.
And you have testified as an expert, been retained to offer opinions.
Many times, yes, sir.
You are familiar with the constitutional cases on police use of force.
I am. I mean, I'm not an attorney, but I'm familiar from a police perspective, yes, sir.
And you try to teach those concepts to others.
From a police perspective, yes, sir. Not a legal perspective, but a police perspective.
And you indicate you have worked on several thousand police use of force cases over the past 25 years, right?
I think 2,000 to 3,000 would just be a fair estimate of applications of force involving law enforcement I've reviewed, yes, sir.
And in this case, this present case involving somebody's liberty, you were asked by the attorneys to review the materials and offer expert opinions concerning the police practices involved, right?
Yes, sir. Not all of them, but yes, police practices.
What were you asked to offer an opinion on?
As best I can recall, sir, the initial focus was on the taser itself. Of course, to use the taser, you have to have a lawful basis to have your feet where they were, so that involves stopping the vehicle, and then whether you would do things once you got there. But it was primarily focused on the stop and then the taser application.
And with all of that, you wrote a report, correct?
I did.
Your report is just over 2 pages long, is that right?
It's 2 or 3. Yes, sir, that's correct.
The opinions that you have, to me, seem to start about halfway down the second page.
I'll have to look. Yes, sir.
So the sum total of paragraphs in which you have opinions would really be 3. Is that right?
What was the number you said? I didn't hear it.
3.
Sure, that'd be about right.
You express your opinions as you have today on the stand in terms of contemporary police practices. Correct?
In response to questions concerning that, yes, sir.
None of your opinions today or in your report have utilized the phrase an objective officer in light of all the facts and circumstances known, an objectively reasonable officer in light of all the circumstances known at the time, correct?
I'm not certain, but that could be.
Well, I'm just saying, the way you have written your opinions, you did not use those terms.
Okay.
Is that true?
What term specifically, sir, am I looking for?
Whether an objectively reasonable officer in light of all the facts and circumstances known to the officer at the time.
I don't think I used those words in my written report, sir.
During your testimony today, you never used those terms to express your opinions, did you?
I don't recall.
Well, I recall, and I don't believe you ever used those terms for your opinions. The only time you used it was in reference to a Supreme Court case, correct?
I don't recall exactly what you're talking about, but I'm reasonably certain you're probably right.
In fact, when you were taking issue with the proportionality concept, you said it's a lofty goal to have proportional force.
Yes, sir.
You don't think that's something of a legal requirement?
I think there are cases that suggest that, but not to the standard of objectively reasonable behavior, which we have in Graham, which is the big focus.
And that was when you said objectively reasonable in referring to a Supreme Court case, which Graham is, correct?
It is, yes, sir.
Mr. Ijames, do you have a copy of your report with you?
I do.
Did you actually write this report?
I did.
Okay. Did you write it before reviewing all of the materials?
I would have written it long before I reviewed anything last week. So I wrote it after I looked at the case that was supplied to me on flash drives.
Okay.
But certainly I learned things last week that would not apply to that report.
All right. And you have a copy with you?
I do, yes, sir.
Your Honor, may I approach the witness to take a look at that? May I look at your copy?
Sure.
At the bottom of your report, below your signature, there are a few lines written there. One of the lines is, I need all of the records mentioned and easy access to the video, correct?
Correct.
So if you needed all access to the records, how did you write this report if you hadn't had them yet?
I don't even know what that is. I had Mr. Ng print this for me yesterday, so that would not have been on the report that I submitted back in September. I didn't bring a copy with me.
The report that was disclosed to us from Ms. Potter's counsel is exactly the same as the one you're looking at. It has that
Okay.
line on there.
I'm just not remembering what that was in reference to. I certainly need all the records mentioned, etc. I don't.
Well, why would that be on your report below your signature if you had reviewed all of the records before you wrote your report?
I would have reviewed everything sent to me up to September. I just have no recollection of what else might have been mentioned. To be candid, I don't understand what that suspended ? Engine status ? I don't really know what that is. So I'm at a loss to tell you.
Yep, so it also says they're suspended ? Correct?
Suspended with a question mark, yes, sir. I really don't know what that is.
All right. In your review of the case, are you concerned about, or curious about something being suspended or someone?
I have no idea. Engine status, I mean, I really don't have any recollection of what
All
that
right.
references to.
I do want to ask you about that one, engine status question mark, correct?
Yes, sir.
You told the jurors today that the whole issue of shooting occupants of a vehicle was not black and white, but it is a concern of shooting somebody who is operating a vehicle, right?
Or behind the seat in any capacity, yes, sir.
Okay. So whether the engine was on in that vehicle would be a pertinent consideration, wouldn't it?
It'd be one step closer to movement, yes, sir.
So at the time you wrote your report, you were still questioning about the engine status?
I just don't remember what that means.
Did you ever find out if the engine was running?
I believe that it was, yes, sir. Keys in the ignition.
In your review of the body-worn camera videos, all Mr. Wright had to do was put it in gear to drive off, correct?
I'm not sure exactly how that vehicle works with brake and gear, but pretty close to that, that would be it.
Well, I think all vehicles require a foot on the brake to put it in gear, right?
I don't know.
Okay, fair enough. At the time of the shot, Mr. Wright's feet were on the driver's side floorboards, correct?
From my understanding of the video, yes, sir.
Now, it's your opinion here today that, and in fact, when you wrote your report, that Ms. Potter only meant to use her taser, correct?
That's my understanding. I've not seen anything to suggest otherwise.
And one of the reasons you believe that is she only pulled the trigger once.
That's a factor. I mean, it's not a significant factor compared to other things, but that's a factor.
Well, probably the largest paragraph in your report is just about that very fact, that she only pulled the trigger once.
I'm just saying there's other factors such as verbalization and
Sure.
things like that that are more reflective.
Okay, but you told the jurors it's not a significant factor, but it took up a lot of space in your just over two-page report.
May have required a few more words to explain that, yes, sir.
And what you're explaining there is officers are trained, if you're going to pull the trigger on a gun to use deadly force, you pull it multiple times, correct?
That's not necessarily true. It's just operationally they do. They rarely pull one time only. In some scenarios, they're taught to shoot more than once double tap. We don't teach to shoot in every case multiple times, but that's more common, of course, than just a single shot.
So when you were asked to provide a report for the attorneys who had retained you in this matter, you pointed out here that the number of times she pulled the trigger was a factor to consider, right?
Yes, sir, that's correct.
And what you said, what you wrote is, police firearms training nationwide generally involves rapidly pulling the trigger multiple times, and discharging rounds is necessary to stop a suspect's threatening behavior.
Generally, as I said, yes, sir. Not in every case, but generally.
Taser training, in contrast, involves a single pull of trigger.
Press and release, yes, sir.
So that was a fact that you put right up front in your report in your analysis of your
Yes, sir.
conclusions. And, I mean, as you sit here today, as an expert, you agree that an officer's use of force is evaluated by the reasonable officer standard.
That's a segment of it, yes, sir, in the Graham case, the reasonable officer standard, correct.
But really for you, it's police practices and training. That's been the focus of your entire career, is training police officers.
Well, the reasonable officer standard is not some magical component of a police officer. It is the fruit of their training, their organizational culture, policy. They just don't raise their hand and get commissioned and become reasonable. We teach them. We try to prepare that. So,
But your perspective, your entire career has been devoted to training officers in their practices and conduct.
to be reasonable, yes, sir.
All right. So you must agree then, by pointing out the number of trigger pulls, that an officer's actual conduct can indicate what a reasonable officer knew at the time.
It would be one indicator, not necessarily everything, but certainly.
So you would have to agree then that because Ms. Potter only pulled the trigger one time as with a taser, there's no reason to believe that a reasonable officer in her position at the time believed that shooting her gun was a necessary use of force.
I think I understand you're asking whether at the moment she fired that. I don't think I should try to interpret that. Could you just say it again, please?
Sure. You would agree that because, you pointed out the number of trigger pulls,
I did.
and you did that to support your opinion that she did not mean to shoot her firearm, she meant to use her taser,
It indicated less likely, yes, sir.
and indicated the use of less lethal force.
Correct, yes, sir.
And so you would have to agree then, since you're relying on it, that because she only pulled the trigger, she did not, a reasonable officer in her position would not have perceived a reasonable basis to shoot their gun, to use lethal force.
Well, I guess I don't know. I've not read any testimony from her what her perspective was, but from what I've seen in the video, and the assessment would be that an officer in her position was not perceiving the need to use deadly force, and so the use of the taser would have been the appropriate tool, and that's what she was trying to do. But I've not heard directly from her, so I just don't know that.
You agree, it sounds like you're kind of saying that this Mr. Smith gave you the opportunity to be the first taser instructor. Is that what you were telling us today?
I was in the first class
Okay.
of the master instructors. There were about 20 of us in 1999.
And proper targeting is a very common topic taught in taser training, correct?
That's a target or a topic that's common and important, yes, sir.
And you agree that good probe spread is important to a taser achieving neuromuscular incapacitation.
That's the primary factor, is probe spread.
That sounded like what you're saying is sort of in the same way as having to shoot somebody in the head to immediately stop them, correct?
That would be more likely than the body, yes, sir.
Okay. But a taser deployment is not always effective at achieving neuromuscular incapacitation.
The best studies are about 67% of the time. From a practical, no excuses, did it work, did it not, about 67%.
So that's a lengthy way of saying no, it's not always effective, right?
I couldn't hear you, sir.
That's a long way of saying no, it's not always effective.
I guess, sure.
And I think your testimony was when a person is sitting down, you might be able to achieve a good probe spread just because they're sitting.
Because of the bend in the body, yes, sir.
But if the taser is only a foot or two away and pointed at the area of the chest involving the heart, that's not really going to, that may not achieve good probe spread.
It just depends on how far the heart is from the thigh. I don't know, but it may or it may not. If they're sitting up high enough that it doesn't get to the thigh and split the belt line, then the answer would be no.
But if an officer is trying to achieve that total neuromuscular incapacitation immediately, that's an important consideration, isn't it?
It's the key consideration for the taser to work, yes, sir.
And you agree that one of the purposes of the taser verbal warning is to alert other officers
It is.
and to let go of the suspect, subject, whatever term you want to use.
I can tell you from a training, do you want me just to answer yes or no or to explain stuff?
Go ahead, tell me.
From a training perspective, the answer could be yes or no. The warning is designed for a number of things. One significant factor is there's been a concern about officers perceiving the pop as a gunshot and somehow reacting inappropriately. So that's one issue. The second is to make sure you're generally out of the path of the probes. If the officer saying that is there and I'm between you and that suspect, I would want to move. Generally, keeping a hold of a suspect may in fact be valuable during a taser deployment. Taser specifically instructs controlling under power, which means handcuffing while they are energized. And so having a hold of them when they're hit, if it occurs safely, is really the best place for you to be, because then you then move to handcuffing and don't have to reach to re-engage. You just put them in cuffs while they're being energized.
But it wouldn't be unreasonable for an officer to let go of somebody who's about to be tased from a foot or two away.
It would not at all.
You testified a little bit about this distinction between operating and driving a motor vehicle, so I want to talk to you about that.
Okay.
You're familiar with, I guess, training or practice on shooting occupants of a motor vehicle.
I want to be responsive to your questions. I don't recall any specific training on shooting occupants of a motor vehicle ever in my career. We have training that involves concerns about that, but there's no block that says today we're going to do shooting occupants of a vehicle. So that's the best way I can answer that. I'm not familiar with that particular block of instruction. I'm familiar with many blocks of instruction that include unintended secondary consequences, like a person in a tree who gets tased and they fall. So I am familiar with training that speaks to what might happen if you shoot a driver.
Okay, so let me back up a little bit. It sounds like you're still talking about tasers, correct?
No, either way, I just gave you an
Okay.
example of secondary consequences of the shot itself.
An officer has to consider secondary consequences, collateral injuries, correct?
Not just with a taser or a firearm, really with everything we do.
Exactly. The example you gave, tasing somebody in a tree, they may fall out of the tree.
Yes, sir.
And you have tried to explain to the jury today, that I think, about tasing somebody who's operating a vehicle.
Yes, sir.
So, but this general notion about using force on an occupant of a vehicle, right?
Right.
Comes from the very common sense and understandable concern that if somebody's driving a vehicle and you do something to them, the vehicle could become an unguided hazard, could become dangerous to others.
No question about it.
So is there training that police officers get and you teach about the dangers of shooting or incapacitating people who are driving motor vehicles?
I'm not familiar with any block that is specific to that, but I'm familiar with many blocks that reference it.
All right, maybe we're splitting hairs. It is a concern, isn't it, that it could cause collateral injury.
Any application of force when a person's involved with a mechanical conveyance, for an example, raises with it the collateral concern of the conveyance itself. It's different than standing in the street if you're on a bicycle. So all training, force application, involves collateral concerns such as an accidental fall down and they hit their head. I've never had a block unique to that, but all, in my experience, involves that.
Does the average officer in the street know this?
You said, does the average officer on the
When
street?
you talk about contemporary police practices and training, and this has been your career, does the average officer know about this danger?
Which specific danger are you asking me, sir?
Well, let me just rephrase the question.
Okay.
Did you review Brooklet Center Police Department policy about shooting into motor vehicles?
I don't recall.
So you're not familiar with the policy that Miss Potter would have been subject to as a Brooklyn Center police officer?
I'm just saying I don't recall it, sir.
In that policy, it talks about discouraging, I'll be kind with my words, shooting at occupants of motor vehicles.
Okay.
Now, would you agree with me that the reason for that is the potential for collateral injury when you disable the person driving the motor vehicle?
I just have to have you hand me the policy and let me read it to get the context. I don't remember it, so I just can't tell you.
But that general concept, do you agree with the general concept that that's the concern, is the risk that causes?
The greater risk that comes to my mind in the question you're asking would be concern about people close by, not the person driving off. So in the absence of reading the policy that apparently expresses the concern you're saying, I'd be guessing to tell you what they're trying to communicate to her in that policy.
Your concern is about others, right? I mean,
I'm saying you're asking me if it's the vehicle driving off. I'm saying my primary concern would be if there's passengers, someone close by would be more of a concern than the person driving forward.
if a vehicle that's being driven, if the driver is shot, it's not going to make them a safe driver, is it?
No, sir.
So that's the danger presented, right? Not only are you shooting that person, but you're putting others at risk because you've got a vehicle that's moving that could harm somebody?
It would depend completely, sir, on the circumstance if we're in a downtown street compared to in the middle of a cornfield. So it depends on the circumstance which one of those would be a greater risk.
I guess I think we're just arguing in circles here. Right?
I'm just trying to answer your question, sir.
And I think we're spending far too much time on this. But what I'm just simply asking you is that a concern for collateral injury if you incapacitate a person driving a motor vehicle?
If you ask it that way, the answer is certainly and quickly yes.
All right. We were kind of going in circles. So you draw the line then at a vehicle that's moving and a vehicle that's not moving.
Well, moving clearly is in a condition to go forward. If the vehicle's in park and the shot is effective, then the vehicle's very unlikely to go forward. So I would draw that distinction, yes, sir.
So if a vehicle has a person in the driver's seat and all they have to do is shift it into drive, that situation doesn't present the same dangers at that moment as the vehicle that's already moving?
It does not.
It doesn't present any dangers at all?
That's a different question. There's
right.
still danger. If they're immediately incapacitated and the vehicle's in park, it's going nowhere. If they're not, then it certainly presents a danger if they have the capability to put it in drive.
You expressed some familiarity with Minnesota law about being in control of a motor vehicle.
I'd read actually, I was curious, and I actually searched the statute, and there was a reference to operating. And it talked about feet, positions, conveyances, just I don't have it verbatim, but it specifically talked about what operating was.
What statute was that?
I can't tell you from memory. I just went to Minnesota statutes and literally Googled the word operating. And it was a statute in reference, I believe it was either car crashes or intoxicated driving. They were just a reference to conveyances or parts of the motor vehicle that allowed its movement.
Could a person under Minnesota's DWI laws be charged with the DWI for sitting in the driver's seat with the keys in the ignition and their feet in the floorboards?
That calls for a legal conclusion.
The objection is sustained.
When you told the jurors that you read some statute, I think it might have been, well, was it the DWI statute?
I just don't recall. It was just a reference to operating, and I just mentioned that in the fact that Minnesota statute even talked about operating a vehicle, so that was the sum total of that.
All right. In your report, you used the term operating/driving, correct?
Yes, sir.
Then you went on to use, in the next sentence, operational /driving condition, correct?
Yes, sir.
If you're drawing the line only at a vehicle that's moving, why did you feel a need to, in your just over 2-page report, add the term operational to that? Why didn't you just say moving or driving?
I don't recall.
Well, could it be that you actually did realize a person who is in a position to drive a vehicle, just simply all they have to do is put it in drive, presents the same kind of concern an officer must consider when they're going to use force on that person?
That would not be true because it's not the same concern, driving versus in a status ready to drive. It's not.
Not the same concern, but a concern.
I've not disputed that, sir. That is significantly concerning, but not the same.
And not a sufficient concern in this case when Mr. Wright is sitting in the driver's seat.
I'm having trouble hearing the question, sir.
Not a significant enough concern for you when Mr. Wright was sitting in the driver's seat with the engine running.
I don't understand the question.
All right.
What are you asking me?
I will ask you. If a subject is sitting in the driver's seat, their feet on the driver's side floor, hands by the steering wheel, the engine running, should an officer take those facts into consideration when deciding to deploy a taser on that individual?
Agree.
Isn't this particularly true if giving the verbal taser command could cause officers to let go of that individual?
It would certainly give that individual a little more time, yes, sir.
Now, it's your opinion that if Mr. Wright had been in a position to operate that vehicle, it was not unreasonable for Officer Potter to consider a taser deployment.
Agreed.
You used specifically the word consider.
Agreed.
It's your opinion, though, that Mr. Wright was not in a position to operate that vehicle.
It's not my opinion, sir. He could have, and proved that he could drive the vehicle. He did it.
In your report, you state, in the immediate case, Mr. Wright was not operating or driving the vehicle when the taser attempt was appropriately initiated.
Correct.
So is it your opinion that he was not in a position to operate or drive that vehicle?
He was in a position to operate it. He wasn't operating it at the time. That's my opinion.
Now, again, you have all this law enforcement experience, 43 years, correct?
I do.
Several thousand police use of force cases over the past 25 years.
Correct.
Right. You have been retained as an expert in civil and criminal matters
I have, sir.
and testified. Right?
I have, sir.
You understood immediately upon being contacted about this case that an officer had shot and killed a man, correct?
I was aware of it, yes, sir.
And her attorneys asked you to offer an opinion regarding the police practices involved, correct?
With the primary focus on the taser. That was our discussion, but the police practices involved with a focus on the taser.
Did they limit you to just the taser question?
Objection.
We're proud of the objection is sustained.
Your Honor, may I be heard on that?
Yes. The objection remains sustained.
So, with all of this experience and in your initial report, you did not at all address the use of deadly force.
I did not, sir.
Did you review Professor Stoughton's report before today?
I did, sir.
And when did you review that?
I don't recall. It would have been in the last month or so.
There was a discussion in that report about deadly force, correct?
There was, sir.
You still did not notify Ms. Potter's attorneys that you had some position on deadly force.
Objection privilege.
The objection is overruled.
I didn't feel compelled to go opinion for opinion with him. My opinions were focused primarily on the taser, and I read that, and I just didn't feel I had any compulsion to go back and say, he has this, I have that. It wasn't that kind of report. I wasn't in an argumentative process with him.
So
I
it
just had to
wasn't-
focus on the taser.
I'm sorry. So it wasn't until the testimony of Sergeant Johnson was pointed out to you that you suddenly had an opinion about deadly force.
When I was asked specifically about it, yes, sir, after I watched that testimony, that was it.
And so it was counsel that approached you about providing a deadly force opinion based on that testimony.
After the testimony last week, yes, sir.
Yeah, excuse me, just a moment, please. And you met with counsel before testifying today, correct?
Last night, he came to the hotel, yes, sir.
And you indicated that you then had an opinion about the use of deadly force, correct?
No, sir, not last night. It was whenever the testimony occurred last week. I didn't see it live. I don't recall whether it was an email or a call, but he then said, hey, I want you to watch this testimony and give an opinion concerning the use of deadly force. The sergeant has introduced this. And, I mean, we talked about it last night, but that wasn't the first time.
All right. And is it true that all you said last night was, given Sergeant Johnson's testimony, deadly force was appropriate? Is that all you told them about your opinion?
Are you talking specifically last night in lieu of any other conversation?
Correct.
Objection privilege, what he told us.
All right. I'm going to let you go a little further.
Okay.
All right. You may re-ask your question.
Is all you told them last night, given Sergeant Johnson's testimony, deadly force was appropriate?
I just don't really recall exactly. I think I would have said a lot more than that.
Your Honor, may I approach the witness?
Yes.
Ask you to review the last line of that, please.
Right. It looks like Mr. Ng writes, given Sergeant Johnson's testimony, deadly force was appropriate. I think he was taking notes during a couple-hour conversation. I can't speak for why he reduced it down to one sentence, but I said more than those words.
Now, Sergeant Johnson did not testify about a reasonable officer in Officer Potter's position, did he?
No, sir.
So the subtotal, and we have to assume, because I don't know what happened in that couple-hour conversation, it sounds like what you're saying today is that based on Sergeant Johnson's description of where he was at the time, that's what allowed you to then now formulate this opinion about deadly force, correct?
It wasn't just that, but that was a part of it.
Even at, well, when you were asked to do the review you did, you had full access to Sergeant Johnson's body-worn camera.
I did, yes, sir.
And you had access to the dash camera from Officer Lucky's squad car.
I did, sir.
And you had access to Officer Potter's body camera.
Correct.
And Officer Lucky's body camera.
Correct.
And you also had the written reports from those, from Lucky and Johnson.
I did, sir.
And the opinion you formed after reviewing that, based on your training and experience, was that Sergeant Johnson was leaning into the car from the passenger side.
Correct.
And today, Mr. Ng asked you to agree that Sergeant Johnson was half in and half out of the car.
I don't recall him asking me to agree to that. I mean, I've seen the sergeant's testimony. I can't tell you exactly where he was. He was probably more out than in, but he didn't ask me to agree to that.
And so this fact that you claim from Sergeant Johnson's testimony, that was the first time you thought deadly force was appropriate?
Which fact are you saying I'm claiming?
Well, when Sergeant Johnson testified about his position,
Correct.
And that only happened here during trial. It never occurred to you before trial.
I didn't assess this from a deadly force perspective in Sergeant Johnson, as I've said. I looked at this case initially and almost exclusively from the key factor from my perspective in my initial assessment, which was the issue of taser, a decision to use, and manner of use. I wasn't looking at it from a deadly force perspective, and so I wasn't trying to opine on every facet of this entire case. The crux of the case is the issue of the taser. And that changed when I was asked. I didn't just decide to do it. I was asked, based on apparently testimony that Sergeant Johnson did, to look at that particular issue, and then I did it.
Your Honor, I would like to show the witness exhibit 63. This is the body camera from Officer Johnson. And I would ask that we put that or go to the moment at 2:01:59.
Permission granted.
You can put it on. I don't know if we need to fire up the thing here. At this time, you would agree that this is the time, from your review, that this is the time when Officer Potter is saying she will tase him. You would agree here that Sergeant Johnson has his hands on Mr. Wright's right arm, correct?
Yes, sir.
And this was part of Sergeant Johnson's testimony the other day, correct?
It was.
This exhibit was shown and he narrated what was going on here? You saw that happening?
I recall that, yes, sir.
Then if we can run this for another second, please. You agree that at 2:02:00 here, we can hear Officer Potter saying taser, one of the three commands taser in the background, correct?
I think so.
And here we see Sergeant Johnson's feet on the ground and his hands holding Mr. Wright's hand
Yes, sir.
over to the right side of the passenger side of the car.
Correct.
Clearly not half in or half out, is he? Sergeant Johnson, I mean.
Well, I don't know how you would classify exactly half, but as I think I just testified to, probably more out than in is what I said a moment ago. All right, so bear with me, please. You testified on direct that when there is a warrant, an officer has to make an arrest. That may vary by state statute, but in my opinion, yes, sir, that's an order from the court.
Well, you told us about a Missouri statute, right? Making it.
I did reference my state. I'm just saying it may vary some by state, but I think that is an order from the court, yes, sir.
I'm not disputing you that a warrant authorizes an arrest. I'm not disputing that at all. But you said it was a mandate.
It is in my opinion, yes, sir. I don't see anywhere on there as a suggestion that says what officer is to arrest.
And, but in making that arrest, officers still have to use reasonable force, correct?
Certainly.
Can't just shoot somebody because they decide not to cooperate with being arrested.
And I didn't hear the question.
If an officer is trying to arrest somebody on a warrant and the person pulls away, the officer can't just shoot him.
Of course not.
You were asked about how many critical incidents in your career you identified. You tried to define that term. Basically, it's a very risky situation for police officers,
I think that's fair, sir.
and others probably as well, right?
In many cases, yes, sir.
And you've been in a lot of those situations,
I have been.
and you've been with other officers involved in those situations.
I have been.
And those are life-threatening situations for you and other officers.
Many are.
Officers were there to help you in those incidents, correct?
They were.
You testified on direct that you got some material, but you didn't review all of it before writing your report. Is that what you
Correct.
testified? Just decided what you'd seen enough, or how did you decide what to review and what to not review?
The file had voluminous medical information, which was not relevant at all to my opinions. Not that I decide I have enough. I just try to commit time and energy to things that make sense for my opinion.
And so then you also testified that a warrant for a gun violation could make an officer more alert about potential danger, correct?
It should, for certain, yes, sir.
Certainly don't dispute that with you, but could that include something like when approaching that person, unsnapping your firearm holster to make it more accessible to you quickly?
It may for some officers, based on their training and experience. For most, the answer is no, but it may.
And that warrant, you're saying, is just one thing for an officer to take into consideration, right?
Yes, sir, just one of many.
Still have to use reasonable force in making that arrest, correct?
Yes, sir.
An officer in making that arrest could also be derelict in duty if they use unreasonable force.
Yes, sir.
You testified about, I think the terms you used were initial scuffle. Do you recall using those terms?
Yes, sir.
But it's true that nowhere in the body cam videos does it appear that Mr. Wright has assaulted any of the officers.
I didn't say he assaulted anyone, sir. I said there was a physical scuffle and he got back in the vehicle. He struggled to control.
My question for you was, did you see in anywhere of the body camera videos that Mr. Wright assaulted any of the officers at the scene?
Okay, I didn't hear that question presented that way. The answer is no.
You talked about body cam videos and the perspective of those, and you said that a slice is helpful to show whose hand is on something, but right, you said that a slice of that video would be helpful to show whose hand is on the shift knob, for instance, right?
That's one example of where a freeze frame is helpful, yes, sir.
But it may not be what an officer would perceive
Correct.
or would have difficulty perceiving.
Beyond question.
But the officer whose hand it is would already know their hand is on the shift knob.
Independent of the video, they would know that, yes, sir.
And that officer, if they are preventing that shift knob from moving, would know that that vehicle can't be moved.
At that moment, if they're effective, yes, sir.
Now, you told the jury that the model Taser policy is one that you wrote up, correct?
I authored the 2007 iteration up to about 2018 for IACP. Yes, sir.
And did you review Brooklyn Center's Taser policy for this
I did.
case? It's not your policy. It's not the one you wrote.
No, it's not the IACP model policy. It's their own policy.
So the standards that you applied for your definition, there were two of them, are not in the Brooklyn Center policy, correct?
They're not that exact policy, correct?
And in fact, what the Brooklyn Center Taser policy is that Ms. Potter acknowledged receiving and was trained on every year, right? You know that, right?
Yes, sir.
She's certified every year. She had to be, she had to go over the policy as part of that training. You saw that in the records.
Yes, sir.
And that Taser policy plainly says that the Taser can be used when the subject is violent or is physically resisting,
Correct.
where the subject has demonstrated by words or action an intention to be violent or physically resist, and presents potential harm to officers, him or herself or others.
That's the language I recall, sir.
Different than the policy you wrote up.
It has different language, and most agencies are more restrictive or add more information than a national policy. Yes, sir.
And you would agree that it is more restrictive in the use of a Taser than your policy.
Than the national best practices policy. Yes, sir.
Why is it the National Best Practices Policy? Why do you call it that?
Because it's from the International Association of Chiefs of Police National Policy Center, created by the largest professional police organization in America that every chief's a member of, in partnership with the U.S. government.
In which you have been a member of for how long?
I've been a member of the organization since probably the mid-'80s and served on that policy board for probably 20 years in one capacity or another.
You took issue with Professor Stoughton's explanation about probe spread, right?
I just disagreed with it.
I'm sorry, I didn't hear
I
you.
just disagreed with it based on what I know about how tasers work.
Okay. You talked about the Taser 7. And it's has a, well, it's true that the Taser 7 you can order with close quarters cartridges.
You can if you choose to.
And you were telling the jurors that this Taser 7 now has a close quarters cartridge that makes it more effective close up.
It spreads further if you have that cartridge, yes, sir.
But at, of course, 1 to 2 feet, still not going to spread much, is it?
I think it's a 12-degree arc compared to the standard 3.5-degree arc.
Did you investigate at all whether the Brooklyn Center Police Department and the Taser 7 that Ms. Potter was using had a close quarters cartridge?
I did not.
And I'm sorry, a little bit out of order, but we were talking earlier about the testimony of Sergeant Johnson. It was suddenly very
Yes, sir.
important to you during the trial, caused you to have this new opinion about deadly force, correct?
No, sir. I was directed to look at it and asked to consider that. It didn't cause me to do anything different.
Have you, well, let me say it this way. You have not in any way tried to assess whether a reasonable officer in Officer Potter's position would have been aware of Sergeant Johnson's position at the time she fired her handgun into Mr. Wright.
I have not.
Your Honor, may I have just a moment, please?
Yes.
That's all I have, Your Honor. Thank you.
Okay. Mr. Amy, you may proceed with redirect.
At the conclusion of your direct testimony, I gave you a hypothetical where the individual in a case like this actually sees Sergeant Johnson inside the car.
Yes, sir.
Does that change your opinion as to whether or not deadly force could have been used by that individual?
My understanding in our discussion last night and today, I was just caught off guard by reading what was handed to me, was that was what we talked about was a hypothetical.
Right.
If it's assumed an officer in this position was aware of that set of circumstances, and that was the basis for my opinion. Yes,
The
sir.
opinion was that
If that officer perceived that that fellow officer was in immediate deadly jeopardy of being drugged, then the answer would be correct. Deadly force would be justified.
and that would be in accordance with the objective, reasonable officer standard that we've talked about earlier today.
In my opinion, it would be, yes, sir.
What would have happened to Sergeant Johnson or Sergeant Lucky if Mr. Wright had put his car in reverse?
Objection, Your Honor. Scope. Speculation.
The objection is sustained.
And we met last night at the hotel where you were staying, is that correct?
Yes, sir, we
And I
did.
asked you to review Mr. Stoughton's testimony too, is that correct?
Yes, sir.
And we've gone over what the areas were that you disagreed with today, is that correct?
I believe we did, sir.
The word retained was used a couple times for you. You were not retained in this case, is that correct?
Not by my definition of retention, no, sir.
Is it a violent felony to flee a police officer by accelerating a car away from them with a passenger in it?
No objection?
Objection. Scope.
The objection is sustained.
No further questions.
Any recross?
Just want to make sure I understand what you're saying. What was discussed last night, first of all, is not included in that memo, that email I showed you, correct?
That 7 or 8 words reduced down, apparently, that Mr. Ring said did not capture what was talked about in the entirety, no, sir.
But what you're saying here today, telling the juries, is if there was a hypothetical where the person knew that Sergeant Johnson was in the car.
That's exactly how I characterize it back to Mr. Ing. If it is assumed this set of facts, then my opinion would be that deadly force was justified.
So you're not offering an opinion about the actual facts of this case, you're just offering a hypothetical.
I don't know the actual facts in this case. I've not heard Officer Potter testify concerning that, so that's correct.
Have you examined other facts in the case to determine that without regard to Officer Potter's testimony?
No, sir. I don't think I understand exactly what you're asking, but the answer is no.
So, for example, you used the number of trigger pulls to reach some conclusions about whether she meant to shoot a taser or a firearm.
It is. The objection is sustained. And it's been asked and answered as well.
So you are telling the jury here only that it's a hypothetical, force could have been used.
I didn't hear the last part, sir.
Force could have been used, deadly force could have been used.
If that set of hypothetical facts are assumed, yes, sir, that's my opinion.
But really the question is, regards whether a reasonable officer in the position that Officer Potter was in, correct?
Correct.
And so then, I want to ask you my own hypothetical. You would agree that if an officer in Officer Potter's position was not aware that Sergeant Johnson could not have exited that vehicle, deadly force would not have been reasonable.
That would not be consistent with my hypothetical, so I agree with you, sir.
And I don't want to get into a battle of words, but you said retained. That would be not be your definition of the word retained. You have not accepted payment for your work, correct?
Correct.
And that's what you mean by you wouldn't use the word retained because you're not paid?
Retention to me is contracts. When people give you a contract and say we're paying you to do this, this, and this, I get many of those in civil cases, but for me personally, retention is a retention letter and a contract, and that doesn't exist in this case.
But what you did here was at the direction of the defense, correct?
It wasn't at their direction. It was at a specific request to assess the facts in the case specifically about the taser, and I gave them the facts from my perspective, and that was that.
Sure. And what I meant by direction was simply they told you what they wanted you to address. But I'm not saying they told you what to say, but they told you what they wanted you to evaluate.
Scope, that's the answer.
I'm trying to define retained, Your Honor.
All right, I'll let you answer that question.
My best recollection is from the initial conversation. It concerned the focus of the case was the validity of the stop and the decision to use and manner of use of the taser. That was going to be the focus of my opinions.
That's the direction you took from them.
Yes, sir.
So whether they're paying you or not, you're doing that for them. You're providing that service for them.
Correct.
That's all I have, Your Honor.
Any redirect? Okay. All right. Members of the jury, I'm going to let you go to lunch, and we'll start up again at 1:30. Okay, you may step down. Thank you.